it's like a lot to go through. I won't go through, but I think I'm trying to understand the gist, the substance of all the questions. First of all, in the friendly settlement, we have asked either formally or through email communications at least a half a dozen times since the beginnings of these proceedings to engage in friendly settlement. We actually think that the Commission's expertise and the awareness of the norms would help tremendously. And so again, we would immediately accept. We'll come next week if you like, whenever. Secondly, in response, I'll try to work backwards. Have actions been brought? Our witness here, Hul'qumi'num, referred to Walker's Hook and the desecration of burial grounds. That was an unsuccessful action that cost quite a bit of money. There have been several actions that have been brought over the years, and the experience has been lots of money spent on lawyers, and the government fails to implement the decision. We have amici briefs, and I disagree with the government. The amici are not relevant. The government cites, we specifically tried to get amici for the cases that the government cited, Hul'quminum and others as well. And their experience confirms that litigation in Canadian systems cost anywhere from $15 to $20 million for Aboriginal title litigation. Let me say this, and the government admits it. There has never been a single instance in the history of Canada in which a Canadian court has recognized 1 square inch of Aboriginal title on either public or private lands. And that really is the issue here, and I'm glad the Commission is focusing on the private lands issue. In fact, there is a clear priority. There's a clear distinction in Canadian law between private lands and ancestral lands. Canadian courts have repeatedly held that Aboriginal title is fundamentally inconsistent with common law private title. Therefore, they will not engage in consultation. They certainly won't give prior consultation and free and informed prior consent. There's certainly no benefit sharing. The government refuses to appropriate. As for so property rights. Secondly, the legal, okay, so what activities? We have submitted extensive documents. I would hate to have you go back through all the affidavits from tribal members who can testify to contemporary actions on the land. The very gifts that have been given to me are used from the land. The cedar that you see, the affidavits specify. You see, here's what's unique. Because we have the 3 large landowners, this land has been largely undeveloped. It's really undergone intense development in the last 10 years. Part of that was brought on by the Olympics. Part of that was just brought on by the real estate boom. So these large areas of land that the Hul'quminum were able to leave their villages and go and collect medicines, to hunt, to gather, to fish. What's happened is that they've been gobbled up. And so what you see are the pictures that we've shown you. They're basically disappearing. And because it's private lands, as these lands become clear-cut, it's an inevitable process. The trees are clear-cut. The timber companies sell off the bare land to real estate development. Golf courses, subdivisions go up, and they lose access. So that's what's unique, is the fact that such large areas were held by private companies that were not under intensive use, and the Hul'quminum had been allowed to use them. That's why they're here right now. And as for the government's BCTC treaty process, if you go through all those documents, we submitted, I believe, over 10 submissions on admissibility, and the Commission quite clearly and unequivocally stated that the BCTC process is not an effective remedy, and I'll summarize right here why it is not an effective remedy. The government refuses to engage in consultation on any developments that take place in private land on private lands. That's the issue here. And because such a large amount of this territory belonging to the Hul'quminum people's ancestral lands is controlled by the Big 3, there's no way the government's going to do that either. Thank you.
Thank you very much, and thank you for your questions. Obviously, we can't answer them all, and some of them, at least one in particular, with respect to the Mabo decision, is really quite technical, and I'm afraid we'll have to answer that one for you in writing, and I hope I've understood it. We may have to ask for further clarification on that one. I'm going to turn to my colleague, Frank Soda, to talk about some of the first questions that you asked, Ms. Sheldon.
Thanks, and we will also provide responses in writing to all of these, and perhaps also seek clarification, make sure that I've understood the questions correctly. But thank you for those questions. So the first one is on the status of the treaties. Are they of constitutional rank? The answer to that is simple. Yes, they are. And can they be changed? Only if all 3 parties to the treaty agree, as set out in the amendment provisions, as you'll find in the Manolf final agreement that's there. The government can't change them unilaterally. On loans, the question, as I understood it, is it a policy of non-collection or a deferral? it's a deferral. Canada is responsible for overseeing taxpayer dollars, and the loans are a contractual agreement that is entered into between the First Nation and the BC Treaty Commission, and the terms are set out clearly there. The policy is of not to collect of withdrawal. There hasn't been any determinations of that, although there's been numerous cases where First Nations or governments have stopped treaty negotiations. There has been no collections ensued as of yet.
I'll just speak briefly to the question that I understood, and I'm sorry, sometimes the translations are not perfect, and I no comment on the translators, but it's just a reality that sometimes it's hard to catch the essence of the question. But with respect to what exists in Canada to determine Aboriginal title, there is a right of any First Nation to commence a case in a Canadian court to claim whatever area of land they claim as their land. And then they have to prove it. And what we've tried very briefly to explain today is that in the very few times when this has been tried, and these are massive cases, it takes a very long time to set out the proofs, to hear the witness of the elders, to look at the maps. At the end of the day, to date, the courts have been saying, well, you're asking us for this, but we don't see proof for this. And you're not helping us figure out where in all of this there is title. That is the problem that's been happening. The thing that you have to realize is the HTG haven't even tried to do that yet. They have never pursued a court case and stood before a judge with their proofs of that circle on the land that they're showing you in the HTG Atlas and say, this is our land, and have a court say back to them, yes or no, or I can't tell, maybe some of it, we don't know. That has never happened. Okay, we do not know. And for that circle of land, there are at least 18 other First Nations who would hope to do the same thing, and they are also not in court. The other thing I would just like to observe is it is very unclear what's going on in British Columbia, whether the land we're talking about is all now subdivisions or not. A lot of it is still mountains and trees, some of it clear-cut, some of it not. It's not all being gobbled up. That's the first thing. And the other thing is, I think I heard that the land is still being used by the Hulquminum people. And I think I'll stop there. Thank you.
Thank you very much to everyone for your presentations today. It was very useful. Now, as I continue to work my way through all the documentation, I have some clear lines in mind as I read through all of what you have submitted. So thank you very much.